First and foremost, I'd like to apologize to the courts for appearing before them today. I'd like to apologize to the victim in this case. I'm not going to use alcohol or drugs as an excuse for anything. However, alcohol was a main factor in this case. But I take full responsibility for my actions because I chose to make the irresponsible decision consuming too much alcohol than I could handle, causing poor, regretful choices leading to my incarceration. I've read the police reports and feel ashamed, embarrassed, and hurt because that's not the person I am. And I wouldn't be standing here today if I would have just been more responsible. I have 4 younger children that I've let down because of being locked away from them, missing out on watching them grow, having to deal with that as a heartache alone. The only thing I can do now is work on myself while incarcerated, take advantage of all programs they offer, and become a better man and a better father, and not give up doing so. I have to make this my last time in jail, and I plan to. I'm sincerely remorseful to my victim in this case, letting her down when I was supposed to be a father figure in her life. I beat myself up over this every day. Over this, wishing I could take it all back. I just hope she can grow up in life and leave this in the past, and that it doesn't affect her future. Again, I'm sorry to everyone I caused pain to in this case.
Buckle up, guys. Today we're diving into 2 jaw-dropping courtroom moments. A man who betrayed his own family stands before the ever-tough Judge O'Donnell, and a doctor accused of twisting trust into fraud. The promise? 2 brutally satisfying endings that will leave you speechless. This intro sets the stage for justice served cold, so let's get started.
Why did you call her after you were in jail?
Because I was told by the detective I was allowed to.
Okay.
I didn't call her, I called my wife and she answered the phone.
All right. And what contact did you have with her about retracting her statement or modifying her statement?
It wasn't retracting. We talked about counseling, going to counseling and stuff, because that was something that they was talking about making them do, and something she said she didn't want to do.
Well, trying to, whether directly contacting her or contacting her through your wife, was wholly inappropriate. And it was further evidence of you trying to take advantage of her at that young age, like you did when this happened.
Now she asked the detective if she could have contact with me when this case was all started. And then when I went to my preliminary hearing on February 11th, I asked the detective and he told me the same thing.
All right. Well, you're experienced enough in the system to have the wisdom that you shouldn't have been contacting her. Okay. In talking to her, having about anything having to do with this case. So, you've in your statement you say you apologized to her, but then in the pre-sentence report you talk about how you don't believe you did everything you're accused of doing and wanted to take this to trial. What's that all about?
I don't remember exactly what I said, Your Honor, but what I was saying was I don't have recollection of what happened the night of. So I wasn't admitting to, I don't know what happened.
Here, the defendant begins his long, emotional apology, drenched in excuses and self-pity. He blames alcohol, claims remorse, and tries to paint himself as a changed man. But the courtroom silence says it all. No one's buying it. This moment builds tension perfectly, as the audience senses Judge O'Donnell's patience wearing thin and the truth about to land hard.
So did you or didn't you do this stuff?
Yes.
Okay. And I got to tell you, it doesn't get much worse than this kind of stuff.
I understand.
And I would note in the record that in 2009 or 2010, you were sentenced to prison on a burglary, released on judicial release, and then returned to prison. after a violation of the judicial release. And you were released January 7th of 13. You went back to prison on another case on May 1st of 13 and got out in August. Went to prison on an attempted burglary, trespass in a habitation, breaking and entering, June 23 of 16 through August 5 of 18. A whole bunch of theft offenses between that last prison sentence and where you are today, so you've had a lifetime of criminal activity, but none worse than what has occurred here. So I've reviewed the pre-sentence report and a victim impact statement. I've considered what you have said, what counsel has said, and I've also considered that they've made a joint recommendation of 96 months in prison. And so on count, and I've considered all the provisions in 29, 29, 11, 29, 29, 12, 13, and 14. In consideration of all that, on count 5, I'm going to sentence you to a term of 60 months. On count 6, I'm going to sentence you to a term of 60 months that will be consecutive to one another, with credit for 143 days. And consecutive sentences are necessary to protect the public from future crime by you and for appropriate punishment.
Sit down, man. Sit down, man.
Sit
What
down.
do you mean, man?
Stay down.
No, man. Get me the fuck out of here, man.
Judge.
Come on.
And-
Took my plea back, man. Get me the fuck out of here, man. Get me out of here. Get me out of here, man.
Sit down.
Get me out of here, man.
Almost done, Judge.
Get me the fuck out of here.
And they
No, man. Get me out of here. Get
consecutive,
me out of here, man. What the fuck you mean, nigga? Get me the fuck out of here. Man, get me the fuck out of here, man.
Let me get my leg.
Get me out of here, man.
Just take him into the chair.
Okay, we're in the chair.
All right.
We'll see you tomorrow.
Put me on your visiting list
Alright.
for jail and prison.
All right, man. Stop touching me, man.
Well,
I'm not doing shit, man. I'm not doing shit.
go.
I'm not doing shit.
The judge slices through the fake remorse with surgical precision. Don't beat yourself up too much. Leave that for prison, he fires back. It's a brutal reality check that instantly exposes the hollow apology. The tone shifts from fake regret to pure reckoning, and everyone watching knows this man's attempt to manipulate the system just collapsed in front of the bench.
Let's see. How about Mr. Hetherington? Looks like you're back there. Actually, I've got maybe another file. Pamela Ronaldo Dicus versus Kirk Gold.
That's correct, Judge.
Do I have Kirk Gold?
Yes,
Anybody?
Your Honor. Kirk Gold is here.
Okay, on that phone it looks like. Mr. Hetherington, looks like I scheduled this for evidentiary hearing for, I guess, the amounts it looks like.
Correct, Judge.
Mr. Hetherington, I guess have the parties talked at all before we proceed?
Yes, for about 2 years, Judge.
Oh, okay. We're so kind of at the end of that. Okay. Mr. Gold, are you ready to proceed?
I'm waiting for my attorney to call me back. I put a call into him because Mr. Hetherington proposed a resolution, and I just need to run it by my attorney to make sure it's the right thing for me to do at this point in time. And it was unfortunate the witching hour yesterday, and I understand and respect this court's time, but I didn't get a response. I expect I'll get a response this morning when the attorney gets into the office.
Mr. Hetherington, I guess I'll leave it up to you if it's easier just to see if it.
Your Honor,
the issue in this case is this has been ongoing for 2 years. We were here 2 weeks ago. He did not bother to call me until Friday morning. I was out of the office. I returned his call yesterday. We did not have an opportunity to fully discuss the matter until yesterday afternoon. He's had a couple weeks to talk to a lawyer to see what the best outcome would be. We are prepared to move forward.
Your Honor, sir, sorry for the interruption. Mr. Hetherington, I did call you the day after our trial. We did speak on the phone, and I told you that I was going to be working on it and seeking legal counsel. And then, yes, I did try to call you on Friday before the weekend, and you were not available.
Now, it is time set for a motion. Who's your attorney?
My attorney is Maury Lefkowitz.
The only thing I guess Mr. Hetherington, I'd allow him to do if he wants to make a quick call, I'll let him do that. If it was the proposed, I guess the proposed offer is something you'd consider if he gets a response from him right now?
Yes, Your Honor.
Okay. So if you want to try to call him right now and tell him that you're right in your hearing and the judge is giving you a chance to talk to him real quick. You want to do that?
Yeah, I'm not sure how I would do that with me being on the phone, how it would.
Well, you can, I'll tell you what, I'll let you hang up. I'm sorry, I just took your number off there. What's your phone number so I get it when you come back on? What's your phone number again?
248 20.
0.
Right.
I'll look for you. If you want to hang up and try to call him real quick, I'll let you do that. But you got to come right back on, okay? Otherwise, we'll end up proceeding just without you, and I don't want to do that either. Okay?
Okay, let me try to call him.
Okay. All right.
Okay, thank you.
Sure.
All right. Yep.
Sure.
Judge O'Donnell starts questioning the man about calling the victim, and his tangled web of lies quickly unravels. Every excuse digs him deeper. The tension rises as the judge points out how contacting her, directly or through his wife, was absolutely inappropriate. This is the breaking point where the defendant's credibility disintegrates under the weight of his own words.
Pamela Ronaldo Dicus versus Kirk Gold.
Ready, Your Honor.
Okay. You come back here. Or do we, oh, there he is.
248 number, Judge.
Yeah, thank you. I just found him. Yeah, he's coming back in.
Hello.
Hi, Mr. Gold. You're back?
Yes, sir.
All right.
Yeah, well, I was actually calling Mr. Rick because I hadn't heard from you for 20 minutes. My attorney's in consultation right now, but he's going to try and call me at 11 when he's finished with his first consultation.
Mr. Hetherington, I'm going to leave it up to you.
I'm trying to get this resolved. I really am.
Your Honor, it's been, like I said, it's been 2 years, and it's been 2 weeks since we were here last, and he didn't call an attorney till last night. We're ready to proceed.
All right. I think at this point we need to proceed then.
Can I have one more chance to at least talk to my attorney and just get an answer for you, Mr. Rick?
I don't agree.
Can I at least do that out of good faith? I know you're trying to get this thing done, and I can appreciate that. But that's just a huge amount. It's a huge amount. If I can get this done and do what we talked about yesterday, then everybody wins.
Well, I thought that's what we were doing right now. I mean,
well, we are. I just have to run it by my attorney first and make sure that that's the right thing for me to do. I mean, that's what counsel's for.
well, it is, but you put your counsel in a bad spot too. He or she should have been called much earlier too. That's the problem.
We had talked, but just we have not connected since.
Mr. Hetherington, I guess if you want to just proceed, we can do it. Or the practical side, if it's a reasonable offer and it looks like it's going to be done.
Your Honor, again, we're ready to proceed. There's been too much delay in this case as it is.
Okay. All right. Let's just proceed with this time then. It is
Please.
just set for evidentiary hearing with regard to the conversions fraud. Do you have a witness, Mr. Hetherington?
Your Honor, I'll just call Mr. Gold.
Oh, okay. Mr. Gold, can you get on video for me?
I'm in the car driving right now, sir.
Well, you can't be driving anyways. You gotta pull over for me. Are you pulled over?
I'm pulling over as we speak.
Okay.
Now, how do I do this?
Just gotta,
I'm on the phone right now.
okay, you just gotta, there's a button that, well, probably at the bottom, it looks like it says video, or it's got a little camera, it looks like. It's got a,
I just have a call screen. That's all I have on here.
Your Honor, I think he's actually on the telephone, not on the Zoom.
oh, you know what? We can
Call
proceed.
that.
Mr. Gold, why don't you raise your right hand for me? You're pulled over though, right?
Yes, sir.
Okay, why don't you raise your right hand for me? You got your hand?
So this
Hold on. You
this
got
is a
your hand
done deal
raised?
then, right?
Well, we're not, I haven't heard anything yet.
Yes, sir.
Okay, you got your hand raised?
Yes, sir.
Do you swear from the testimony you're about to give will be the truth?
Yes.
Okay. Mr. Hetherington?
Thank you, Judge. Mr. Gold, where are you employed?
I'm in private practice.
What kind of private practice?
Podiatry practice.
So your title is a doctor, is that correct?
Yes, sir.
And back in 2023, is it true that you entered into an agreement with the plaintiff in this case to borrow the sum of $12,000?
Yes, it is.
And did she in fact give you the $12,000?
Yes, sir. She did.
And was the agreement that you would repay that amount within 6 months?
I don't remember the specifics exactly, so I can't attest to that under oath.
Do you recall making any payments on that loan?
Yes, I did make one payment or two
And was that
payments.
for-
I'm not sure.
And was that for $1,000?
Yes, sir.
And so you would agree that you still owe $11,000 on that loan, correct?
Yes, sir.
And that occurred, that loan actually occurred back in May of 2023, is that true?
Yes. I think it was
And-
May. I'm not sure exactly what the date was.
Okay, and then you used that money for some interest personal to yourself, is that correct?
Correct.
And since that loan and since that initial payment, you've had discussions with the plaintiff in this case
Yes.
about repaying that loan?
Yes.
And you've not made any additional payments, is that correct?
That is correct.
And then in January of this year, did you receive demand letters from me?
I received a letter, I believe it was in the early part of February.
Okay. And then we had some discussions, correct?
Yes.
And I provided you with opportunities to try to solve this matter, is that correct?
Yes, you did. And as I stated to you then, and I'm saying to you now, it was a cash flow with insurance issue, and I was trying to rectify that, and I see it starting to become rectified, but it looks like the cart is in front of the horse a little too far. I'm trying to catch up to it. I can't quite reach it, but it looks like I can reach it now, but it looks like I'm out of time.
Now the truth corner arrives. When asked if he actually did it, the man mutters yes. And the entire room seems to exhale in disbelief. The judge's tone hardens. There's no coming back from that admission. It's a chilling moment, the kind that makes you realize some people only confess when there's nowhere left to hide. Justice feels closer with every second.
Okay. But you were gonna be paying though $1,000 per month starting, I guess, when was that supposed to start?
I believe the month after the loan was initiated to me.
You did make, it sounds like one payment of, was it a total, one lump sum payment of $1,000 at some point?
I I do not recall if it was 1 of 1,000 or 2 of 500. I don't remember exactly.
How did you make that payment?
By check.
A check, some sort?
Yes.
Was there a discussion as far as being late on that payment with the two of you?
On that payment, no, that was on time. That wasn't late.
Okay.
And then we had
What-
discussion as time went on. And I said to her that my intentions were I still wanted to pay her, but I just was having cash flow issues and cash crunch issues, etc.
Okay. And what did she say when you asked her about that? Saying that you had
She
cash
seemed to be
flow
okay with
issues.
that. She seemed to be okay with that as long as I was going to continue to pay her. And unfortunately, I didn't make the effort. I didn't show the effort that I wanted to, that I should have.
Okay.
I'm looking back, it was the wrong thing to do. But as I told Mr. Hetherington yesterday, I want to rectify it, even if I got to start with this and do this, and this.
Okay.
And he brought it to his plaintiff.
The money that the 12,000 that the loan was given for, part of the allegation is that it was disposed of without her consent. Meaning that apparently
I'm not
they're saying that there was some type of an agreement that you could only use this money for a specific thing. Is that true or not true?
I don't recall that to be true at all. I don't recall that at all.
Okay.
I do not recall that.
Judge O'Donnell now exposes the man's entire criminal past, a timeline of thefts, burglaries, and repeat offenses stretching over years. The courtroom grows heavier as it becomes clear this isn't a first mistake. It's a lifelong pattern. The audience can feel the final sentence approaching like thunder. The judge's calm delivery makes the impact even more devastating.
And for my sake, then this loan was sometime in May of 2023. True?
I'm sorry, the judge speaking.
2023. The loan was somewhere around in May of 2023.
That's correct, so
So it's been,
couple of years.
yeah, been 2 years, it looks like. Mr. Hetherington, I guess I don't have any further questions. I did ask for as far as what this was payments were for, you did, and it says she said just payroll.
That was her understanding when the loan was made.
When he was, yeah, but she also said that, ma'am, is what you stated, you said as far as you knew the money was used to make payroll?
Yes, doctor and I were in clinic and he was on the phone and he got off the phone and said that he was unable to make payroll and could he take a short-term loan to pay his upcoming payroll. He has one person he employs as administrative person in his office.
Okay. So part of your complaint alleges that he was using money for personal gains somehow, but I don't hear that. And why don't you be upfront with me? Don't tell me anything else. If
I
that's
guess I
not the
can't-
case.
I
I'm
guess
sorry.
I can't be sure exactly what he's actually used it for. Since the time that the loan was given, he has continued to travel and he's bought a much larger home. So I guess I can't specifically know
Yeah,
what he's actually used the money for, Your Honor.
sure. Yeah, I'd rather just be upfront with me. So, okay. All right, Mr. Hetherington, anything else?
Sure, Your Honor. No further witnesses. I'll leave it at that.
Okay. Okay. I guess, Mr. Gold, you get a chance to call any witnesses you have, including yourself. You've already testified to a point, but if you have another witness, you can call that witness, or if there's something else you want to tell me with regard to your side of it, I'll let you do that.
The only thing I'd like to say is, like I posed to Mr. Hetherington yesterday, is I want to make resolution on this, and I really wanted to consult my attorney and get his okay, but since I can't seem to do that and we're at the witching moment now, I'm just letting you know that those are still my intentions. I still plan on doing just that.
I don't want to hurt anybody, and I don't want to, carry this on further than it is. I understand that it's gone on for a long, long time, and it's all my fault for that. But I do want to make good on it. I just know that if we get that penalty, that's going to be just a ginormous amount. But it wasn't my intention. I didn't defraud anybody.
Sir.
I didn't say I was using it for that.
Hold on. I haven't made any decision. He's giving me his argument for his side, okay? After all the
Yes,
proofs
sir.
are in, he's get a chance to do that. I was, quite frankly, gonna hold off till we came back on, but it's probably better now in case there's some discussions. From your side, I guess, Mr. Gold, you've got a final argument. Is there anything that you want to tell me as far as the argument with conversion? Why I shouldn't grant conversion, or
Yes, sir. Because it wasn't a loan to obtain funds to use them for purposes other than my living and my payroll. I wasn't using the funds to gamble, to go and invest in crypto, or to do something that would be completely absurd. I was using them to live and to make payroll. I mean, my payroll is for living. I wasn't doing anything extravagant. I was just trying to survive. So the fraud, I mean, it's not what happened at all. I committed zero fraud. I didn't do anything of the nature. I simply used the money for payroll, for expenses, and to live. That's all it was used for.
The sentence drops, 10 years in prison, and instantly the courtroom erupts. The man loses control, shouting, thrashing, cursing at everyone around him. It's chaos, his composure shattered, his fate sealed. The judge stays stoic while deputies hold him down. The outburst is the ultimate confirmation of who he really is. Justice isn't just served, it's unleashed.
I made no representation, and I didn't do anything that would violate any kind of fraudulent activity. I did none of that. So I don't know that that's really correct. I don't know how the court would view that, but I did nothing fraudulent. I took out a loan and I just didn't pay it back. And now I'm intending to pay it back.
Okay.
I mean, yes, it's to the witching wire now, but I want to get this resolved. Yes, it took too long to respond and reply, but kind of got a wake-up call. Pay it back now. Do the right thing.
all right. So I've heard argument from both sides. I'll review my notes regarding testimony taken in the meantime, and render a decision. If it just by chance, Mr. Gold, your attorney contacts Mr. Hetherington, or your attorney and yourself contact Mr. Hetherington in the meantime, you can certainly discuss it before I make a decision, but I will make a decision on the claim for conversion. There's a claim for fraud too. I'll consider both of them as far as what I've got as far as evidence. Okay? So we'll do it that way. Why don't we come back on and let's see. Let's say, how about we say 11:30? I might be being too positive about it, but 11:30 or so. Everybody come back on.
That's fine, Judge. Mike, does my client need to be here for that, or?
I'll leave it up to you, Mr. Hetherington. We've taken proofs and everything's in. You've made your arguments. She doesn't have to be here, but no.
Very good,
it's up to
Judge.
you.
She has some other appointments, so I'll probably have her released, but I'll be back on at 11:30.
Okay, Mr. Gold, same with you. You got to come back on though, but if there's any conversations, I suggest you talk to Mr. Hetherington in the meantime, okay? Before I make a decision. All right?
Okay, one more time on that, Judge.
I said,
Repeat the last
if
part
you
again.
if you get a hold of your attorney between now and the 11:30, make sure you contact Mr. Hetherington, your attorney or you or one of you, okay? But I'm going to make a decision when I come back on here. Okay?
Your Honor.
All right.
Yes,
All
sir.
right. And we'll leave it at that. Okay?
Thank you, Judge.
All right. You're welcome. And do we have Mr. Gold? Did he?
I'm here, Your Honor.
Oh, there he is at the top.
Yes, I'm here. I almost called, and I didn't know what happened to you. Last I heard was Peters and you were going to get some water.
Yeah, that got hung up on some other matters in chambers. Have the two of you talked?
Your Honor, we have, if I may, I can put the terms of an agreement on the record.
Sure.
So Mr. Gold has agreed to pay a total amount of $15,650, which is the $11,000 that he owes currently, along with some attorney fees. That is going to be paid $2,000 starting this Friday.
Okay.
And then $1,000 each week until paid in full. He will also execute a pocket consent judgment for the $35,660 that we're seeking here, with credit for any payments that he makes prior to that if he should default. In return,
Time out, sir. I think we misunderstood what I said. When we were talking yesterday, I said 2,000 on Friday, 1,000 next week, and 1,000 a month till it's paid. 1,000 a week I cannot afford it. That'll ruin me.
Judge, I guess we don't have a deal, Judge.
Is that what the interpretation was?
Well, that's what my client will agree to. So,
but I asked you, and you said you're going to bring that back to your client, and then you came back and said it's a goal.
I did, and when we spoke at 11:30, right before we logged back in here, that was the agreement that I put on the record with you. Well, that I talked to you about, and you said okay, so I was putting it on the record. But if you don't agree to that, then we'll just let the judge make his ruling.
Oh, sir, I can't. 1,000 a week? God, no, I mean, that'll just put me in default. I mean, it'd save the courts the time and just say I'm going to go into default right now. I mean, I want to pay, but I when we spoke yesterday, I said 1,000 a month until it's paid off. So 3,000 like between now and next Friday, and then 1,000 a month, and then we're done. I mean, I know that he might have heard or thought I meant 1,000 a week, but 1,000 a month will pay off. It's 8 months. And
Mr. Gold, Mr. Gold, it's either there's an agreement or there's no agreement. And quite frankly, I guess it's your decision. You know, if you want me to follow through with my decision, I'll go ahead and do it right now. But I can see what's happening. This is being dragged on every time you turn around. It's being stretched further. So if you got an agreement, fine. If you don't, I'll just make a decision here.
Can we stretch it a little bit? 1,000 a week is gonna cripple me.
We shift to the next case, a smooth-talking doctor who borrowed $12,000 and never paid it back. His excuses pile up, waiting for a lawyer, delays, confusion. But beneath the calm courtroom tone, you can sense the same arrogance we just saw punished. 2 years of stalling have led him right here, face to face with accountability. Don't forget to like the video, subscribe to the channel, and we'll see you in the next one.
I mean, I know that I'm past the prime now, but can we at least make it so I can breathe? That'll suffocate me. I mean, I'm willing to do the 2,000 Friday and then 1,000 next week, and then go from there. But 1,000 a week? Can we go longer? A little longer?
That's not what my client agreed to, Judge. So I'd ask you to make your ruling.
Okay.
I mean, I'll send the $2,000 Friday, no problem, and 1,000 next week, no problem. No problem at all. I mean, I want to get this done,
sir, you're wasting a lot of, quite frankly, my time now, and I've got another trial I'm getting ready to start. I thought this was going to be a simple one. Apparently not.
So did I. I thought that we agreed to 1,000 a month, but okay, 1,000 a week. I'll send the money and 1,000 a week. I'll get this done.
Okay.
If he's agreeing to that, Judge,
on the court cost.
With that,
if he's agreeing to that, Judge, I can prepare a settlement agreement for his signature. Of course, my clients, myself. I'll do a conditional dismissal with a opportunity to reopen if he should default with a pocket consent judgment. Again, that'll be for the amount that we asked for in the default, which is $35,660 minus any credit for payments that he does actually make before he defaults. And in order to to enter that pocket consent judgment, we must file an affidavit of default with the court, which we would be willing to do. If he satisfies the settlement agreement, then we will enter a order with prejudice dismissing the case.
Okay. All right. We'll do it that way then and expect the consent judgment, I guess, with the conditional dismissals, really what it is. But
Very good, Judge. I'll get that drafted up today and over to Dr. Gold.
all right. All right. Good luck to both sides.
Thank you, Judge.
All right. You're welcome.
Thanks.
All right.